The question is whether an advocate be a full-time salaried employee. That means an advocate get full-time employment. That is the question. Can an advocate get full-time employment? The answer is no. Where it is? Part 6, Chapter 2, Section 7, Rule 49. So, according to Part 6, Chapter 2, Section 7, Rule 49 of Bar Council of India rules, an advocate cannot get full-time employment. So, what is the law? We will see. The exact Herbert Marley. So, an advocate shall not be a full-time salaried employee of any person, government, firm, corporation, or concern. How long? So long as he continues to practice. So long as he continues to practice, he shall not be a full-time salaried employee. Prohibited. Full-time employment is prohibited. Suppose if he wants, if he got any job on taking up any such employment, what is his duty? He should intimate the fact to the Bar Council. He should intimate the fact to the Bar Council on whose roll his name appears. That means each state is having Bar Council. Bar Council of Delhi, Bar Council of AP, Bar Council of Telangana, Bar Council of Kerala. So, on whose rolls his name, etc., whose role his name appears, and shall there he has to intimate that he got such employment. Suppose advocate become a judge, then he has to inform to the Bar Council that he got such service. Or any other public prosecutor, any other not public prosecutor, any other post, government employment. So, in such cases, he has to inform. What happens then? He ceases to practice as an advocate. So, thereupon, he ceases to practice as an advocate. So, he cannot practice as an advocate. How long? So long as he continues in such employment. Suppose such employment he resigned, or he completed, or it is lost, then again he may come to Bar Council and resume to his practice. Permission to practice. So, this is 49. This portion has been deleted. This proviso is there earlier, but it has been deleted in year 2001. So ultimately, full-time salary is prohibited. If he got such employment, he has to inform the bar council, concerned bar council. Thereupon, his practice will be ceased. In the same, we may got some doubt. Suppose part-time, can advocate do a part-time job like that too connection with academic issues? For that, the same part, same chapter, same section, rule is different. That is 51. Part 6, chapter 2, section 7, rule 51 says yes, advocate can do part-time job regarding academic issues. What is that part-time job? You say. So, an advocate may review parliamentary bills. We know that the number of bills will be passed in parliament, thereby becomes acts. So, at the stage of bills itself, an advocate may review, he can explain, he can analyze about that bills. So, he can review parliamentary bills for a remuneration. For that, he may take money also, fees also. Next, edit legal textbooks. Legal textbooks are there. You know that number of authors will write books, or number of publishers will publish books, journals. So we can do that. The advocate can do at a salary. By taking salary itself, he can do. And newspapers can do press vetting. So we know that advocates normally contribute to articles and newspaper essays. That means examinations. Vetting means examination. Suppose any judgment has come, any incident has come, any judicial incident is there, so they can do press vetting for newspapers and coach people for legal examination. So students, advocate can give coaching for legal examinations, judiciary examinations. So coach, set and examine question papers. He can prepare question papers, he can set question papers, and subject to the rules against advertising and full-time employment, engage in broadcasting, journalism, lecturing and teaching subjects, both legal and non-legal, even teaching also. But what is the limitation? Full-time employment. I am permitted, so I will teach full-time in any college. We cannot say like that, because you are prohibited from getting full-time employment. You are only permitted to have part-time employment. So, you can teach, you can give lecture, you can work in journalism, in broadcasting, or other creative works, press writing, review parliamentary bills, or other things an advocate can do. This is the answer. And part-time employment, particularly this is academic. Part-time employment also one provision is there. That is Rule 52. Already we discussed the chapter and part and other things. So, Rule 49, Rule 51, Rule 52 are interconnected. 49 deals with full-time employment. 51 deals with part-time academic activities. And then 52 deals with part-time employment. See what 52 says. According to this 52, nothing in these rules shall prevent an advocate from accepting, after obtaining the consent of the Bar Council, part-time employment. So here two conditions are there. Nothing in these rules shall prevent an advocate from accepting. So, no rule is preventing an advocate from accepting part-time employment. One condition is there, obtaining the consent of the Bar Council. So, consent of the Bar Council is one condition. Another condition is that employment, the nature of the employment does not conflict with his professional work and is not inconsistent with the dignity of the profession in view of the Bar Council, the opinion of the Bar Council. So, that part-time employment should not, in the nature of employment, which is in conflict with his professional work and should not inconsistent with dignity of the profession. So, dignity of the profession is to be maintained either in this rule or in 51 or 49. Why these rules have been framed? We have to understand that all these rules have been framed to protect the dignity of the profession, to protect the privilege of the profession. Privilege means advocate is a privileged member of the community. He is having exalted position in the society. So, to protect the dignity, independence of the bar, of the dignity, of the decorum of the judiciary, these rules have been framed by Bar Council of India. So, ultimately, an advocate can get by part-time employment with the permission of the Bar Council, and that employment should be in the nature of, does not conflict with his professional work and is not inconsistent with dignity of the profession in the opinion of the state Bar Council. And this rule also time to time decided by the Bar Council of India. That means if any time to time directives are there by Bar Council of India, this rule is subject to that directives. As of now, this rule is there. If any direction has been issued by Bar Council of India, this 52 rule is subject to that directions. So as earlier said, this is only for the protection of the dignity of the profession. By saying that I am an advocate, can we do any labor work? Can we do any undignified work? We cannot do. So this is the intention behind these rules. So ultimately, by reading all together these rules, we can understand that advocate cannot get full-time employment but can get part-time employment. That academic work also can do. Thank you.